School International Law and Human Rights Clinic, the Armenian Law School Students Association, the Armenian Students Association, Glimpse, help me here. Thank you. A student-run foreign affairs publication and the Global Policy Institute. Thank you. Welcome. That's me echoing, which happens all the time. Thank you for being here, and thank you for taking the time to listen to what can be both very complicated and really very simple. That is, what do small countries do in international arenas with international law at a time when it seems like the whole world has decided there is no such thing as law, not in our neighborhoods, not in our countries, and certainly not in the world. So we're very happy to have Mr. Yeghishe Kirakosyan here from Yerevan. Mr. Kirakosyan represents Armenia in international law tribunal. And in case you want to know how that happens, this is what you do. First, you get a bachelor's in law, in jurisprudence from Yerevan State University. Then you get a master's in jurisprudence from Yerevan State University. A couple of years after that, you get a PhD in international law from Yerevan State University. And because you want more, then you get a Master of Laws in International Legal Studies from Georgetown, and then a Master of Science in Law from Stanford. And after all of that, you get to become Armenia's rep in international law tribunals. We're very happy you're there, and we're also grateful that you're here.
Thank you. Thank you.
And we've agreed that Mr. Kirakosyan will make a presentation, and then it's all your question.
Yeah, I'll be brief. Thank you for the introduction, Selby. And I think today, I'm sure all of the Armenians are closely watching the processes that have been initiated by the Republic of Armenia before international courts. And the experience that I'll be describing to you is based on my the first-hand application and of international law, or making attempts at enforcing international law globally. And I have been appointed to this position since 2018, October. First, my mandate included mostly representing Armenia before European Court of Human Rights, which is mostly relating to individual applications. But at the time when I was appointed, we didn't have any interstate legal proceeding at any court whatsoever, and Armenia has never had a chance to initiate one. That's another story. Why is that the case? Because the region in which the country is a specific region. It has a specific heritage of being a post-Soviet area, and being a post-Soviet area brings with it also some nuances, features that countries share commonly. And one of those is a little bit distance between the understanding international law and actual international that is applied in the countries, in the Western countries, in Europe, or here in this continent, or it understood. And that's why it creates also some sort of gaps in understandings and perceiving international as it is in reality, because Armenia has not been a sovereign state for quite a long time, especially during the Soviet period. And when we got our independence in 1991, we didn't had the chance to engage properly, also because we had the same educational system. We continued the same thread of the chain of the processes that were set during the Soviet period of time. That's why the change and shift happened very gradually. But I'll fast forward you to 2020 so that I don't bore you. And we had the work that I did between 18 and 20 is crucially different, and compared to the part of my work that I started doing, starting from the September 27 of 2020 until now. We had, of course, the major trigger event, which was the war, 44-day war in Artsakh, which brought many casualties and systematic violations of human rights, crimes against humanity, war crimes being committed. And this inevitably led Armenia to choose this path of initiating interstate proceedings before international courts. In general, there are two main international courts that Armenia can bring interstate claims against another countries. The first one is the European Court of Human Rights. I'm sure you've heard of this court, although in this continent you may not know that many details about that court. It's a bit further down in Strasbourg, but the court is particularly a human rights court, which means it's adjudicating individual applications against member countries when the member countries are assuming certain commitments under the convention towards the individuals. But the court also has interstate jurisdiction, meaning that the countries, member states of the European Commission, are allowed also to bring claims one against each other if the other country, they think that the other country is responsible for violations of human rights of the individuals under its jurisdiction. And what did Armenia? We initiated actually the first case at the European Court of Human Rights. That's the and just to tell upfront, there are different terminologies that are being used. Not sure whether all of you are law students, but at the international courts, there are like two types of proceedings: the urgent proceedings that the countries are requesting, meaning that you're requesting interim measures. Those are measures that you request the court to apply in order to preserve certain interests under the convention until the case is adjudicated completely with a judgment. So we did that. We applied to the European Court of Human Rights during the wartime, when the war started, to request the court to oblige Azerbaijan to abide by certain obligations during the conduct of the hostilities. And also we had the instances of capturing of POWs, civilians who have been treated very in an abusive manner, inhumanly, tortured, and the necessity was to oblige Azerbaijan to apply these interim measures to have this safeguard for securing the lives of the persons fallen under the control of Azerbaijani agents. This is the proceedings that we brought, and of course we have also initiated the main interstate case, which followed this urgent proceeding later on, which covered most of the part of the 44-day war and the immediate aftermath of the war, which included many types of violations. And this and Armenia also initiated proceedings before another court. This is International Court of Justice, which is the main court of the United Nations. We initiated an application based on a very famous convention, now famous internationally, meaning that this convention has been used by a number of states for this purpose. That's the Convention on Elimination of All Forms of Racial Discrimination. That's a key convention, very important convention. Just I want you to bear in your mind, because this is, I put this convention on the equal footing with the Genocide Convention, because I consider that the values set protected by those two conventions are similar, as the third is operating to prevent genocides from happening. Because what Armenia brought to the attention of the court in its application and instituting proceedings, we are claiming the decades-long Armenophobic, ethnic, and racist policies of Azerbaijan against ethnic Armenians, which have created favorable platform, favorable environment for commission of very heinous crimes against humanity, war crimes, and grave breaches of Geneva Conventions, which eventually can unfortunately lead to a genocide too. That's very important to highlight that. And Armenian instituted proceedings at the International Court of Justice. At the same time, we applied for urgent measures at that court, but by that court, that's called a little bit differently. It's called provisional measures, but the meaning is the same as I described a couple of minutes earlier at the European Court, the interim measures at the European Court of Human Rights. And of course, the small state, being a small state, of course, we are trying to benefit from these international legal tools created to help countries to enforce international law. And what do you think, like whether how we succeed or not? Because in today's international community, countries there's this gap between the actual the state of affairs on the ground, especially in some countries, and the prescribed values on the paper. There's a huge gap. And this gap has been increasing for over the past decades. The reasons for the increasing of the gaps, we can discuss it differently, separately, but it's there. One of these examples, I think it is exactly Azerbaijan. We have a country, we have an autocratic country, which is highly vertically organized, and it's somewhat challenging to enforce this kind of decisions in this regard, in this context. And you don't succeed that easily. And as opposed to national courts, when you have set enforcement mechanism, it's easy to enforce that. But on international level, that's quite cumbersome, because you need to create multiple levels and multiple factors that are helping you to enforce the decisions or the judgments that you have. Because when you are, for example, imagine that you have a legal proceedings at an international court, within the meaning or within the atmosphere of the court, you operate with different rules. You operate with the legal procedural rules, you provide your evidentiary materials, you provide your argumentation based on the analysis of the evidentiary materials and try to justify your case. But as soon as you have the decision, or you have a decision or a judgment of the court, then you transfer to the implementation phase. You start thinking of how am I going to enforce this judgment or decision. You are transforming to political realities, because you are facing inevitably the realities of international affairs as they are now. Because you have, with regard to the ICJ, for example, the International Court of Justice, we know that we have the main political body of the UN, the Security Council, which is the forum to discuss, in cases necessary, the enforcement issues of the International Court's decisions and judgments. But you can think of yourself whether today, how it's going to look today, what kind of political and other challenges are going to be there today. And in this context, you can also ask a question whether having this kind of environment that helps to create enough leverage to impact the country's behavior, whether country's behavior changes when you have, for example, a decision applying provisional measures with regard to a country. And my experience is the following, because the impact is there. I shouldn't be doing this if I don't believe in this process. I do believe in this process. I do believe that, although I don't see the immediate impact now, I know that in the long run, these legal proceedings are leading to very important qualifications to be given by the courts. That's a long run perspective. That you can use those qualifications and conclusions in a political manner, in different fora. I mean, international, multilateral, bilateral, and different aspects. You can use that as a very persuasive argument. But there can be also immediate impact of this decision. I wish that impact was more, but unfortunately, it's not that often you see that. You see the opposite often. I'll bring an example of the two courts. We have this interim measure or the urgent proceedings at the European Court of Human Rights, when you are applying to the courts and asking for an interim measure for a particular object or person, and the court is giving a decision. You have a similar proceedings at the ICJ, which, as opposed to the proceedings at the European Court of Human Rights, is public, and the European Court proceedings are not public. They are written proceedings mostly. And this difference has some impact in realities. For example, I'll just bring one small example that may also be very interesting for you to consider. Maybe that can also be a trigger for some discussions. When Armenia applied to the International Court of Justice last fall, along with the application instituting proceedings At the courts, we also submitted to the court the request for indication of provisional measures by the court under the convention. I remind you, we're speaking about the ICJ, and that's the convention based on the Convention on Elimination of All Forms of Racial Discrimination. And Armenia requested, among other things, to oblige Azerbaijan to stop the hateful rhetoric by the political leadership, to oblige Azerbaijan to comply with its obligations with regard to the captives of ethnic Armenian origin, oblige Azerbaijan to preserve and protect Armenian cultural heritage on the territories under its control. And we had also one particular request, which was relating to the famous military trophies park. The military trophies park was a park opened in Baku right after the end of 2020 hostilities for the war. And the park was famous for its the exhibits of Armenian soldier mannequins in a very racist and gruesome manner. And also it had helmets, an alley constructed from helmets of fallen Armenian soldiers. And the request was to shut the park down because that goes in vast contrast with it violates fundamentally the object and purpose of that treaty. It diminishes the meaning of that treaty at all for that. And of course you remember that before that hearings, I mean, it was in October, hearings were in October 2021. We had many international organizations already condemning the park. And the park, and what we had, the interaction that we had within the framework of the provisional measures, we received, we saw behavioral change in Azerbaijan. And we received a letter confirming that Azerbaijan has removed the mannequins and the helmets. And then we had the public commitment made by the agent of that country that they are not going to exhibit those articles again. And that's a small behavioral change that we've seen. And largely, I describe that this is due to the publicity of the proceedings, on the one side. On the other hand, you had already a build-up prior to the decision. I mean, different international organizations have been condemning that action. I mean, the military trophies park particularly. And I think the build-up and actually the publicity created that momentum to impact the behavior of a country. And this is not a legal research subject to think of, but it's really interesting to think what is impacting it. But I'm sure that the process of decision-making within the court and by the judges, it is impacted by many factors outside the court. And the reality that the courts and the judges are operating, and whatever it is directly impacting the thinking of the judges. And of course, this is one way or another. That can be not only by the condemnations by international organizations and actors, that can be also academic pieces or some articles that are discussing this topic or that topic, which is directly or indirectly related to the conflict. And this is also part of the mechanism of enforcement of international law. This is overall what's happening in this overall the structure or the architecture, what's happening in the international legal proceedings initiated by Armenia. I think I don't want to go in more details. I'm just laying down this structure so that you have the understanding where it is starting and where it's going to. And maybe it's better now to stop here and to open for questions, and then we take it from there. Thank you.
Thank you. I want to explain two things to give this context. This is what happens when you ask a jurist to talk about war today. He's dispassionate and quite clinical in the way in which he is explaining what jurists try to do to stop man's inhumanity to man. So let me set up the political context. Two things are happening. One is that during these last several weeks, Azerbaijan, Armenia's neighbor to the east, has attacked Armenia, sovereign country of Armenia, with all of the implications for law, regional peace, and all of that. The context of that is that since the collapse of the Soviet Union, Armenians who lived within an enclave in Azerbaijan, in sovereign Azerbaijan called Karabakh or Artsakh, have said they want the same right to self-determination and independence that all of the other Soviet republics had a right to. As a result of that, there was a military conflict lasting 4 years. Armenians not only managed to hold self-governance in Karabakh proper, but also in territories around it for protection and possible bargaining purposes. And all of that held for 30 years until 2020, when Azerbaijan, which is a petrostate and a dictatorship, and I say that because I'd like to start with those two questions, used its resources to militarily seize not just lands that it claims as its own, but also to do away with citizens that it claims as its own. And so it's a complex regional situation that has to do both with a sovereign state attacking and invading a neighbor sovereign state, and at the same time, the rights of citizens that it considers its own citizens and the human rights and the protection of those rights. So this is the complex situation in which all of this is happening. And my question to you, my first two questions, and then I promise no more, the rest is you wanted to title your talk International Small States and International Law. Well, what if it was big states? What would be different? Number one. Number two, the fact that this conflict is between Armenians in the Republic of Armenia and also within the Republic of Azerbaijan, and Azerbaijan, which is a dictatorship, a kleptocracy. 30, journalists are imprisoned at rates that are higher than that in Russia, and on and on. So what happens when a conflict is between a democracy and a dictatorship versus some other kind of conflict? So I will start with those two and then your questions.
Thank you. Thank you. Those are very important, interesting questions. And the first question relating to the difference between small states and big powers. What would be different if that was not a small state? I think it's quite big states, or like states like US, like the US, they have much more tools to pursue their interest, to follow up on their interest, to enforce what they want to do, and to but small states don't have much resources. I think Armenia, like Armenia, small states, they do not have many resources, and among those limited resources, and having speaking the language of international law, it's adding up a lot of arguments, let's put it in that manner, or it substantiates more the positioning and the interest of the country in the international relations. It does. It amplifies the voice also when you start trying to fit your agenda or fit your interests within the meaning or within the structure of international law. And with regard to the second question, whether was how it is to enforce international law with regard to dictatorships like Azerbaijan, that's adding up a lot of challenges, because that's what I meant when I was saying there is a huge gap between the values on the paper and the values in the reality. And Azerbaijan is one of these best examples of such country, which has gone so far in that regard that it's really hard to enforce the actual decisions of the international courts, which are trying to bring the country back to the values. And especially in the case when we're speaking about the application of the Convention on Elimination of All Forms of Racial Discrimination, that's particularly emphasized, because this you cannot undo the decades-long Armenophobic racist policies in one day or one night or 1 month. That's not possible. I understand that. Like the country will need a generation to change, because the propaganda has gone so deep that it created generations based on hatred. And Aliyev himself, he admitted after the war that the victory that he had was thanks to the generation of people brought up in a spirit of hatred towards the enemy. That was very openly admitted. This is, and that's makes it even harder, because dictatorships, they will try to avoid, they will try to bend international law, they will try to misrepresent things, they will try to misrepresent the facts, which is happening over and over. And we are seeing that in the recent escalation when we had a direct attack by Azerbaijan on undisputed sovereign territory of Armenia, but still we got the narrative from Azerbaijan that the Azerbaijan was the victim of the attack, which was nonsensical because the armed activities and the armed conflict was happening near Armenian cities, villages, or no, resorts, etc. and so forth. This is nonsensical. Yeah, this is in 2 words.
Thank you so much for joining us and sharing such a complex matter in such little time. I think my question is more relating to like the interference that international big powers have in like this small limited area where small states have. So my question is like putting into like an example, like how important is like a big power support to a small state when you're like doing these international appeals? And I say that because recently like Nancy Pelosi had a visit to Armenia, but at the same time we see that the US trades weapons to Israel, who in turn supply them to Azerbaijan. So it's kind of like a very conflicting way to show that you're allies. So I think in those terms, I was wondering, how do like big powers partake in like helping small states and when it comes to like international courts?
That's when it comes to international courts, I'll try to answer that, trying to understand or trying to describe the impact that this may have or is having on international courts. I'm sure that it is having, and the conducts by big states or big powers, or not particularly not only the conduct, but also the words or statements or assessments of the situation. They are having direct impact, I think, on the situation. They're moving the things one way or another. They are impacting the force. That goes without saying. And in the courts proceeding, the force, they are supposed to be clean, and the legal proceedings are supposed to be as sterile as possible, meaning it should be just a legal proceeding with your argumentation and your evidentiary materials, and the court and the judge should decide based on the materials provided by both parties and trying to analyze who is right and who is wrong. But in that analysis, of course, a lot of factors can play out, and many factors, starting with the conduct as you described of the big powers, ending with the statements made by international organizations, going that far as a publication of different articles by renowned scholars in specific topic, on specific matter, which relates to the case at hand, that can impact too. And that's also created that impact is bigger or is much more profound as opposed to the national courts, because international courts are mostly very distant from the scenery of the conflict. When they are distant from the scenery of the conflict, this understanding of the complexity of the conflict is lesser. So they like that creates this vacuum which can be filled with many factors. So that's why the processes outside the court, they truly and directly impact what's happening inside, and that's not very good. That shouldn't be the case, but I think it's a fact. And today that's even becoming easier, because today you all can see also countries trying to manipulate with the international opinion, trying to direct the international opinion to the course which is more favorable for them. That's being done through soft tools, to trying to promote the ideas and positions through different commission papers, different articles, and etc. And it's done easily because it's not only previously the academic scholarship was more closed community. Now, because of the internet and because of the blog starters multiplying, it's so easy to and quick to publish small, very superficial analysis of something, which, but then in the end of the day, that creates an impact. People read that, people share that, and then it goes. And yeah, sorry. Sure.
I have a question about the military park. So I was wondering, what exactly was the basis that the International Court of Justice mandated that to be shut down, and if, like, what did they declare, what was the exact issue, and why has that not extended to their, like, warfare tactics and things like that?
Yeah, I don't have and it's I would love to show it on the projector for you to see the how the mannequins look and how the helmets are looking. But yeah, if you've seen them, yeah, that's actually quite it's, to put it in mild tone, it's quite racist to put in that manner. It's not, if not more, it's completely disregarding the principles of the convention. But just to clarify, the court didn't order to shut it down, and the Armenia presented a request asking to shut it down, but we had in between the submission of the request and the actual order, we had some development by Azerbaijan coming to the court and saying we have removed the helmets and the mannequins from the park. So that impacted the court's decision. The courts acknowledged that Azerbaijani agent came and publicly made this announcement and statement and committed not to re-exhibit those articles again. So that's what and the park actually it goes. If you're asking substantively, it goes completely against the provisions of the CERT, because that's a brutal violation of that. You don't do that. By the way of park, they are preaching, they are continuing to preach hatred towards ethnic Armenians. That's what they're doing. So that's a part of policy. Yes. There are two.
Given Russian invasion of Ukraine and now Azerbaijan of Armenia, do you think more states will be inspired to take military action regarding disputed reasons such as like Taiwan or Taiwan? If so, what can international human rights organizations do to reduce this risk?
I think what's happening in Ukraine has a direct effect on what's happening in our region, very directly. And I think the aggression by Azerbaijan against Armenia, and it is very directly connected to the events unfolding in Ukraine. And I agree that the invasion, also not only the invasion, but the invasion and non-condemnation, and the actual not qualifying that as an invasion or as an attack on sovereign territory, and the follow-up on that, not only describing or qualifying that as an attack, also acting on that. I mean, you need the Security Council also to continue being seized of the matter and to pass a decision or to have a resolution on that. Although it's not, it's really hard to imagine how it is going to play out, but still. But the answer is yes. That's encouraging more invasions, which is not stabilizing, of course.
Yeah, I'm wondering, despite the fact that you mentioned the racial content,
yes,
is clearly an issue, but I'm wondering why, considering that there's actual military action being taken, that seems to be an indirect route to the claims that are so much bolder and more obvious in terms of the attack on a sovereign state. Why take the indirect route? Is there a more direct route?
Yeah, thanks a lot. There are, like, in international law, there are very strict boundaries when and based on which convention you can bring a case to the court. You need a jurisdictional basis to bring a case to the court. And the events that you mentioned, I mean, the aggressive attack on sovereign territory, that's a violation. That's a very strong, a complete violation of the Article 2.4 of the UN Charter. But the UN Charter does not have a jurisdictional basis for the countries to start litigation in international courts. That's the answer to the question. That's a very formalistic legal answer. So. There is a question.
How do peacemaking entities such as the OS group, how do they affect the legal proceedings for a country like Armenia?
Now they don't affect, because there is there is nothing happening. But of course, the effect of those the mediation efforts and the process of mediating conflict, it would have impacted what's happening in the court, because that's the materials there will be used by the court in the cases, but that, I think, only to that extent. There's
Thank you again for coming in. My question has two parts. First of all, what are the different kinds of damages that the court can award? For example, do they do primarily monetary damages or injunctive or damages like that? In that case, you also mentioned earlier about the enforcement of the different decisions. Is there any involvement in the court? Like, just can they bring again to the court saying you gave us this judgment, but they have not paid ever required damages? Is there any system like that to make sure that the judgment is fulfilled, or is there somebody who goes over the countries and checks on it?
Yeah, that's depending on which court we're speaking. If we're speaking about the European Court of Human Rights, both courts will be, of course, awarding damages when they find violations. They will be awarding damage compensation for pecuniary and non-pecuniary damages, both the ICJ and the ECHR. And the answer to the question how you monitor whether this is implemented or not, like two different mechanisms are applicable there. You have at the European Court of Human Rights, the political body, the Committee of Ministers, which is the body to oversee the implementation of the ECHR's judgments, which is happening periodically. They monitor, they convene, and they discuss, and they receive the reports from the country which should be implementing the judgment, and then they make recommendations and make decisions. That's the mechanism. And you have the Security Council for the ICJ, which is a bit more difficult to act, considering the political environment and geopolitical realities and the permanent membership issue. But still, that's the way you enforce. Those are the two mechanisms. Yes.
Please, okay, to continue the question building problem.
Mhm.
Isn't the toolkit of forcing the decisions very limited because of the international organizations? Like by saying that, I know that there have been some decisions, say, with all companies in Russia that have there have been decisions by the court that some people were to be paid compensations, like in case of other costs, if I'm not mistaken. But then it hasn't been implemented yet. What is the toolkit of these organizations to enforce?
There is no police. There is no police to enforce that. Yeah, that's limited. Unfortunately, that's the case. So international structure or international judicial mechanism, they have shortcomings. That's one of them. You have that environment, but that's depending on many factors, including political realities. That's inevitably impacting the processes, and that's why I was emphasizing that the courts the process inside a court, and also that when you're ending the process inside the court, you're transforming to the implementation phase of the decision or judgments. Then you change the rules of the game, and then you are in much more unpredictable environment because you don't know what factor and which factors are playing out there, and you have to be very attentive. But just I want to emphasize the value of decisions and judgments. It's twofold, and of course that's the compensations or the violation damages claims to be awarded. That's one impact. That's immediate impact for the victims. It means that the victims of those violations will be receiving some compensation. But the second impact is political. It's more long-term impact that should have, and that's the impact in terms of the qualification of the overall situation. I mean, when you are having, or the court, for example, saying that Azerbaijan is in violation with the fundamental principles of the CERD, then that's an argument. That's a very important milestone. Then you have to, based on that, you have to continue. Yes.
Thank you for coming to talk to us. What limitations in terms of jurisdiction did you have in the last war of 2020 when Azerbaijan was attacking its international recognized borders within it, and now it's attacking another sovereign state? What additional?
There are no jurisdictional. If you are asking whether we were prevented to bring a claim in one case and where we can bring a claim in this case, right? That's the question. If we're speaking about the European Court of Human Rights environment, no difference. Still based on the articles of the European Convention on Human Rights, we as a country, member country, we are allowed to bring a claim in protection of the victims of the violations that are being committed by another member state. Disregarding of the qualifications, no, it doesn't matter. Like just for like equally enough, Cyprus could have brought the claim against Azerbaijan, so just for you to have an understanding. And with regard to ICJ, is different because in ICJ, you do need to have a specific jurisdictional clause based on which you bring a claim. That's different. We can discuss that if you want, but it's quite lengthy. It's another lecture.
Case where employers have become citizens of Artsakh as opposed to Armenia, like in order to gain more legitimacy in international court, since you're representing something from the internationally speaking right recognized under your jurisdiction.
Challenges if when representing citizens of Artsakh as opposed to citizens of there is no difference in that. Just I think it's the more or less the continuation of the same question. There is no difference in that, like whether I am representing, because the violation could, if the court has the jurisdiction to consider or to entertain the dispute, and the court has a jurisdiction to adjudicate that, then it can pass a judgment, and it's the same. It doesn't matter. So we're still, for example, the 44, the application that is referring to the violations of committed during the course of the 44-day war, which mostly the victims are people of Artsakh. Like you have over or close to 90,000 victims, that including those who have been forced to flee and leaving their houses and the property, which is, and many other number of articles have been violated. That's one of the core fundamentals of the case. So that's equally being considered. There is no like particular difference. Yes.
Regarding action taken with the UN framework, I've been reading recently about discourse within the UN and actions taken that, well, there has to be unanimous agreement between all the Security Council members. And Russia has been acting as a deterrent to any discourse or action taken that would secure Armenian interests in the UN. And I've seen recently that US and France and other countries who are interested in these in this situation are making a push to exclude Russia from Human Rights Council of the UN. So I was wondering how feasible is this, or from an international legal perspective, what would be the steps to securing that?
You mean excluding Russia from the Human Rights Council? That's
The Human Rights Council, yeah, how feasible is it?
how feasible it is. I don't know. I really don't know how feasible it is. It is maybe more or less it's due to the procedures of the council membership. I cannot elaborate on that now, but I'm sure it's feasible. I'm not sure where the process is because I don't have enough information to answer the question. I really need more. Yes, please.
So Turkey and Pakistan is one of the states that were openly supporting Azerbaijan and committing war crimes against Armenians. So I'm wondering, is there like a legal tool to punish the state that was supporting?
Armenia has a case against Turkey at the European Court of Human Rights. I forgot to mention that. We initiated proceedings based on the European Convention, submitted a complete application in May 2021. The application relates specifically to Turkey's direct involvement in the conflict and making Turkey culpable for all violations committed during the conflict, during the armed conflict. And not only that, not only direct military involvement, but also through the recruitment, financing, and using of mercenaries. That's also another part of the method of violation, because through that, an additional human rights violations have been caused. So that's the way. And with regard to Pakistan, you under international law, you really need to be very cautious and careful. It is very specific system. You need to have a jurisdictional basis for trying to sue the country. So if we are speaking about European Court of Human Rights, that's a no-go, of course, because that's Council of Europe, not a member. And with regard to the UN or the ICJ, you need to look at the possible, first of all, possible jurisdictional basis. That's first. But secondly, you need evidence. That's also important. Evidentiary materials are highly key in any judicial proceeding. Yes.
Thank you again for coming. I just wanted to ask about the implementation processes within international courts, like we said, and how they have shortcomings. Do you think there's any future coming, like, do you think there's any future regarding these implementation processes that are going to expand beyond what they are now? Is there anything that can be done aside from international and public pressures?
It's a good question, but I think it's very hard to answer. I think the system is having its own. It's fine. It's challenging times now. Maybe the overall international architecture of and also in adjudicatory architecture. And also because of what's happening now, that's quite simple that the institutions are at some point they are failing. And including the international judicial institutions, they are not completely fully functioning. And maybe the system created after the Second World War it really needs a fundamental change. But the problem with that is, for that change to happen, you need global some agreements, at least reached on very principal and basic matters. And today, I hope that will come soon. I really hope that time will come soon, but I don't see it in near future, unfortunately. The courts, each court has its own methods to assessing the monetary damage. Both the European courts and the ICJ, they have a specific methodology defined how they assess. For example, the CHR has this method of assessing it based on the market value of the property lost, for example, and then based on that they calculate the monetary damage. More or less the similar approach can be undertaken by the ICJ. And of course, you have the non-monetary compensation, which is very famous at the European Court of Human Rights. You have the non-pecuniary damage to be awarded. That also has specific principles developed by the president of the court, depending on the violation, whether it's right to life or it's a prohibition of torture. It depends. The amounts are dependent, and depending on also the GDP of a country, responsible country. That's also a variable to be taken into account. Yeah.
One more question. Call it. Sure.
Considering the narrow claims that additionally the fact that Armenia has very few resources and a lot of these things are decided, the factors are extrajudicial. What would you do if you had to use those limited resources in order to improve its position on public relations?
One of the most important things that this countries like Armenia needs also to be more mindful is the messaging that is delivering to the world. That's very important. Messaging in a very broad sense of the word, because the work in the judicial institutions and the judicial legal processes are nothing without the diplomatic work. Because if you don't do if the diplomats don't do their work, you don't you don't go far. Really, that's very important, because if you have to, that's a kind of a network. If you are claiming something, if a country is saying, if it's claiming something or presenting a claim to another country, it means the country is leading the foreign policy in certain direction. Based on that, it means that the processes and the policies should be structured based on that approach, and it should be working like a network. That's very important. Otherwise, you won't have an effect.
In other words, the next time we have a panel like this, a discussion like this, there should be 4 people on it.
Yeah.
There should be the communications person, the political science person, the jurist, of course, and the international relations person, so that all of it together will possibly bring us back to the values that you very clinically referred to, but at the end of the day, that's what this is all about.
Yeah,
right? It's
yeah.
human rights and people's right to life. Thank you.
Thank you.
This will be up on YouTube for those of your friends and family who missed it.